there should be some outward manifestation of the prohibited behavior. Whatever prohibited behavior, since we can't visually see any behavior, so the behavior is getting manifested in the form of an outward action, isn't it? In essence, what we can say is, for an individual to be found guilty of a particular crime, there must be an observable action of or omission. So action includes, act includes, omission also. So what we try to say is, you have to book an individual, or say an individual guilty of a crime only when there is an observable action, or at least there should be an observable omission on the part of that violates the law, and that should also be prohibited and specifically being defined in the law. So that is the in essence. Now, but however, we know that mere thoughts or intentions alone are not sufficient to establish the criminal liability, because as I said, thoughts and intentions can never be seen outwardly, isn't it? They have to manifest themselves outwardly in some kind of an action, isn't it? Now, actus reus can take different forms altogether. Now, it can be a commission of a prohibited act at times. So, all property offences like theft, assault, or arson, so these can be some examples of an act which are that is squarely prohibited by the law, isn't it? Now, omission also is an act, because the definition of act includes even omissions also. Now, in certain cases, we know that failing to take an action when it is legally required, where there is a legal requirement that you need to perform an act and you are failing in doing that particular act, then that also constitutes criminal offence. So, to understand it better, for instance, suppose failing to provide necessary care to a dependent person might lead to charges of neglect. So, when you have already taken a position of a guardian, and then legally you are bound to look into the needs of the dependent, isn't it? So that is an act which is legally given to you, and then you are supposed to oblige that particular act. And if you fail in that act of taking care of the dependent, definitely that will be a chargeable thing, offence, and then that can be charged under the neglect. So we can call that as he is neglecting his duties. Now, actus reus again is, there must be an offender, and if the offender is animal, can we say that it can constitute actus reus? If suppose in place of human being some animal is there, can the animals be punished? Can they be punished? So, in order to have actus reus established, so offender has to be there. My point is, do we definitely have to take only human beings as the persons, or can there be an animal also? Can animal also be punished under criminal laws? Offender invariably has to be human being only. We have all provisions of penal punishments and all, keeping in mind the human beings. Now, when you take the definition of a person, instead of human being, if we say a person, now person has been defined in several places, in several acts differently. So, person need not be a human being, it can be a legalistic person, juristic person also, legalistic person. So, in that corporates, companies, isn't it? They all come under that category. So, it has to be human being or a person. That is one thing. And another character feature of the crime is, act is committed by that offender. There must be some observable, visible, perceivable act that should be committed by the offender, is the second important character of the crime. Now, once the act has been committed by the offender, it should lead to some consequences. So, every act or Every act will have its consequences. Now, after commission of the act or the offense, if it is leading to some evil consequences or rather bad consequences, if they flow from the act itself, then a guilty mind of offender accompanies it. So, an act which the offender is committing, and there are some consequences which are flowing out of that act, and they seem to be evil consequences, and plus you should have a guilty mind. That is, we said, mens rea of the offender, which accompanies his act. So together all these things are becoming they are becoming very characteristic features of the crime or offense. Now, there should be some material object or some object or some weapon kind of a thing, using which the offender must be committing a particular act, ultimately leading to the commission of a crime. So these are very much essential when we talk of or give a definition to the crime. So when we say a person, as I said, person can be an individual in the form of human being, it can be a company, it can be an association or body of persons, whether incorporated or not. Every company need not be incorporated, a simple incorporated body or not. As I said, legal or juristic persons, and certain sections of IT restricted to natural human beings only. Of course, you also have the definition for persons under General Clauses Act under section 3 subsection 42. It clearly defines what is the definition of a person. So when we say in a crime, in order to have the definition of a crime, we need to have a person, that is namely the offender, and we should also have some act being committed by him, and that particular act should have some consequences, and these consequences definitely, if they are going to be deleterious or harmful or some evil consequences are following, then, and definitely evil consequences are prohibited by law, and in addition there should also be some kind of a guilty mind. So if all these ingredients are there, then we say they are the characteristic features of the crime. But among them, when we list out in consequences and all, so certain things listed are called actus reus, and then of course guilty mind is the mens rea that we can think of. Now, act committed by offender. So what do we understand by act? As we have already discussed that in the last class, some movement, some muscular contraction as a result of the operation of his will. There is a will already in his mind. Since we can't see will or intention or his desire, these are abstract things which go on as a thought process in the mind, which nobody can understand, neither perceive nor can see. So the outward manifestation of that behavior or intent or intention, whatever that is there in the mind, gets reflected outwardly by an action. So that means there must be some muscle movement, and then this muscle movement comes outwardly because there is already a will, there is a desire in the mind of the person. This is the definition for act committed by the offender given by Holmes, Holmes, Holmes. Since today you just have to bear with me, since my laptop and all is not functioning, I have to do it through mobile only. You have to just bear with me for today. Like that, there are several criminologists who try to define the offense or the crime. So Austin is one scientist, and then Stephen, of course. There are a number of criminologists, but then mostly we say Austin and then Stephen, they are the ones. Now, more or similar, Austin also goes by that definition that whenever we say act, it has to be some bodily movement, and consequent upon the determination of the will. That's what Austin says. More or less it is the same as we said, muscular contraction and it is the manifestation of the will that is operating inside the mind of the person. Now, guilty act, there must be some visible movement of the body in any action that being prohibited by the law. So, the qualifying feature of the act is that it should be explicitly be prohibited by the law. And of course, in sections, if you see omission, as I said, act also includes omission. Now, when you say evil consequences flowing from the act, what do you understand by it? Now, part of the act or part of the omission, both of them can be called as, or if the combination of them is there, even in that case also, we call that as actus reus, which constitute the offence. It need not be completely act or completely omission. Part of it can be an act, part of it can be an omission. So any of these permutations and combination, if this is there, then we constitute that as the actus reus, ultimately culminating into what is called the offence. Now, if you have to take now, mere achievement of prohibited consequences are not sufficient to attract criminal liability. So, in all crimes, you have to establish criminal liability. For example, let me say a boy of 7 years committing an offence. So, that is a prohibited act, isn't it? Under the definition of offence, it is a prohibited act, hence it can be construed or called as an offence. But then when you have to fix the criminal liability, how far we can fix him? What is the liability? What is the criminal liability of the boy? If you try to legally examine that, then we say the consequences of what a person does if he is unaware because of his tender age and all. If a person is unaware of that, then definitely no criminal liability can be attributed to that person. So that way, in order to attribute a criminal liability, what is the capacity? What is the understanding? What is the knowledge that the person has? Whether he is ignorant of the consequences that are flowing out of the act, or is he aware? So that will decide the liability of the person. So in criminal cases, we call it as criminal liability. Of course, in civil matters, we call it civil liability. So to understand it better, let us take an example and try to understand. Now, let us say A wants to kill Z, a person. So intentionally he wanted to cause the death of that person. So he can do it in several ways. One is partly by omitting to give food to him, and partly by beating. So it can be part of action, part of omission. So in first case, he is not giving food, that is omission. In the second case, his action is reflected in the form of beating of the person. So we can say A has committed murder. So in this example, in one part there is omission, another part there is action. So part of action, part of omission. So both together can also be called as the offence. In this particular case, murder. Now, a deed can be harmful, it can be destruction of property, or at times it can be taking away life of a person, but still may not be crime at times, because as per the definition, whenever a act is prohibited by law, then if somebody does that act, definitely it attracts punishment and he is an offender, no doubt. But then law also has given certain exceptions. A deed, when resulting into an evil action, evil consequences, that is, it is harming somebody, it is destruction of property of somebody else, or maybe taking away the life of the other person, but then also it can be legally given sanction. We can still say it cannot be punishable. So under law, certain harms are permitted. That means not all harms are punishable. There are certain harms that are permitted, that are given sanction to be inflicted on the other person. Now, for example, a person who is duly appointed is an executioner, and then he has to do the duty, official duty assigned to him, that is putting somebody to death, after all a condemned criminal. And what is he doing? He is legally, whatever duty is assigned to him, he is doing that. When somebody is doing a duty which he is legally bound to do that, so he is, no criminal liability can be attributed to such person, isn't it? Though killing a person is no doubt a murder, but then he is doing it. Is there intention on his part? Yes, there is an intention. Intentionally he is doing that, and then he knows the consequences of his action. That is, if he executes a person, he is going to die. That knowledge is also there. The consequences which are flowing out of the action is also very much known to him. Yet his particular deed, his particular act, though it is harmful, though it is destruction, though it is taking away somebody's life and all, yet there is a sanction for the action, and then he is said to be not doing actus reus. He is commanded by law. That means the sovereign is giving him a command or some order to do it, which he is legally bound to do it, and hence he is performing it. So under law, there is no criminal liability that can be attributed to him. Hence, we can say that while performing the duty of an executioner, though he is taking away the life of the person, yet it is a lawful duty which is assigned to him. Hence, it is command given by the law. Hence, he is not liable for any criminal punishment. Am I clear? Yes, I am not getting any responses. Am I clear about this? Any point of time, if I am not clear, no hesitation, because I can't see your face and understand your, by expression I can't understand your feeling. At least had it been a offline class, I could have had good eye contact, I could have guessed at least. But this is online classes and all, so this difficulty is there. Unless you speak out in times of crisis, it will not be possible for me to guess things. Now, prosecution, as I said, in all criminal, yes. Who is this? Disturbance in voice. I am trying my level best to avoid all that. Since my laptop has gone out of order, I am just trying to do it through my mobile. Others are not facing, are others also facing the same kind of problem? I mean, is it some modulation problem or what is it? Resounding? What is it? Distorted ka matlab, I mean not clear or reverberating or because ऑफिस में प्रॉब्लम है बोल के आई एम डूइंग इट फ्रॉम क्या है but in the other room my husband is sitting and he is also joining. He says it's okay, it's there is no problem, that's what he says. But anyway, I cannot do better than this. So my point is, except for that, I mean, otherwise the concept wise I think I am quite clear about things, and then there should not be any problem in understanding, because those who have no background of legal study and all, it will be little difficult for them. But I am only concerned of those who have no background, If there is some difficulty in understanding concepts and then definitions, I am always there to repeat them once again. I hope I am clear about things. In case any difficulty, please speak out. So, in absence of any other issues, I am going ahead. Now, we know that in any criminal proceedings or trials, it is but natural that the burden of proof is on prosecution, and in doing that, they have to do two things. One is establish that the act was committed, the offence was committed, and the same act is forbidden under law, that is actus was res. So these two things need to be established, and the onus is on the prosecution exclusively. Point number one is establish that in fact the act was committed, number one, and number two is that particular act is explicitly forbidden, prohibited, and if somebody breaches that, there is always a punishment. That means actus was res. So these are the two main requirements that a prosecution always has to prove in any offence. Now illegal omissions also, we said, itself is punishable, though there may not be any harm flowing out of it, but then illegal omissions are also punishable. Now, for example, I am just familiar with the old laws only. For time being, just bear with me if I quote only the names of the old law, but then as I said, only the nomenclature has changed, but then not much change is there in the content. Just bear with me for some time if I use the old sections and old acts. So there is one popular 144 section, as we call it, which speaks about, of course, the unlawful assembly and all. So is, per se, if you see, mere assembly, and when that assembly becomes unlawful, that is punishable, isn't it? And of course the 124A is also very important. Now we'll talk about it when we come to that particular section in detail. And of course there is another section 351 which talks about assault. To understand it, let me just take an example. There is one A and he shakes his fist and then he goes towards Z, knowing that Z believes that A is about to strike Z, then the offence that is committed by A is said to be assault. That means he is giving all indications by shaking his fist, by pointing, by going towards Z. It clearly shows that he has created intention in the mind of the Z, that and Z also strongly believes that now it is my turn, A is about to strike me and he is about to hit me. So that kind of feeling he has already created because of the proximity. He is not picking up a phone and then he is trying to threaten. He is very much before him, and then by his actions he has given enough indication to Z that he has very much, he has got a strong intention, and then Z also knows that he is about to beat me and all. So in that case we say that A has committed an offence called, though in this particular case what you observe is there is nothing, no evil consequence that is following. It is only creating a kind of a knowledge in the mind of Z that now when he has raised his fist and when he is approaching me, the probability that he will hit me by all chance is what is the knowledge that Z is having in his mind. So in that case, though no evil consequence of the act of A has flown out of the act, still we call it an offence. So in this particular case the offence is called assault, and it gets its definition under section 351. Now you have to understand the act also as a causation, chain of causation. Now in any criminal case, harm suffered by the victim, that is the event, and every event is a product of plurality of factors. That means there are several factors, a number of factors that govern each and every act. Now they are causes of the event. If you see, law does not go into cause of causes, but with proximate cause. What is the proximate cause? The remoter the cause, the greater will be the difficulty of proving mens rea. So if you have to prove the mens rea, if the cause is too remote, then it will be very, very difficult for the prosecution to prove the mens rea there. So it has to be, the more proximate it is more easy for the prosecution to prove the guilty mind, or rather the mens rea. Then, to assess the physical element in criminal liability, because I told you that we need to fix up the criminal liability. To what degree he is liable and all, that has to be established. We can understand this physical element in criminal liability by understanding the concept under different headings. It is like this. If the participation is direct, then we can say that the person is fully liable. And if he has done physical part wholly in the actual commission of the crime. So to understand this particular head, we can do it by taking an illustration. What is the illustration all about? Now there is A, he has got a strong intention to kill B. So he achieves this by shooting at him, and then he intends to kill B by using a weapon, that is a pistol, and then he also loads the weapon, and then he shoots at B. Now it is a deliberate action. He has got an intention. He does that act by loading the pistol, pointing it towards B, and then he is a good shooter, A is a good shooter, and by shooting at B at point blank, he knows that B is going to die definitely. Now the act of A is now undoubtedly, there is no doubt that the act can be construed as actus reus. So what is the first heading says? Where the participation is direct, that means A is the offender, he is participating in the act directly, and then he is fully liable when he has done physical part wholly. What is the physical part here? Shooting at the B. How is he achieving that? He is loading a pistol, aiming at B, and at point blank he is doing. So he is very sure that this act is going to definitely end in some evil consequences, that is the death of the other person, namely the B. So definitely this particular act is direct and wholly in the actual commission. Physical part is direct and whole. Hence, definitely whatever act that is done by A in this particular instance, we can say undoubtedly it can be construed as actus reus. That means an act which is definitely punishable and prohibited under law. That is one heading that we can understand. The second heading is, suppose where there is no physical participation, isn't it? No physical part. In first case we said there is physical participation, wholly he has contributed, every act resulted in the death of the person. So hence undoubted, there is no iota of doubt in that particular case that the act of A is undoubtedly actus reus. The second instance is that where there is no physical participation. That means person has not at all taken any physical part in the actual commission of the crime. Then a person may be held fully liable if he intentionally joins with the actual perpetrator, instigates or advises him. See this. Now, I have not physically participated. There is no action involved, but yet if I join hands with that group and I have knowledge, intention, and I am also the actual perpetrator, I am trying to instigate, I am trying to advise, give a piece of advice, then a joint liability can be attributed. So though the person is not actually participating, there is no physical participation, yet since I am a part of the assembly and intentionally I am joining, there is an intent, common intent there, and the actual perpetrator may be somebody else, but yet by my act I am instigating him, I am giving lot of advices to him, hence that particular act can also be called actus reus, because there is an intention, there is a knowledge, and I am intentionally joining, there is a meeting of minds and all, common intentions are there, hence such an act can also be called as actus reus, though there is no physical participation in the commission of the particular act. Now the third heading is where the participation is indirect. So first case there is direct participation, second case there is no participation at all, but yet it can be construed as active actus reus because intention is very strong there, and I am trying to instigate, give piece of advice, and thereby there is a common intention there. So joint liability can also be there, hence it is also punishable and can be called as actus reus. Now in the third instance there is an indirect participation. That means, what do you understand by indirect participation? Person may not directly participate in the actual commission of the crime, but may do things which have led or allowed an innocent person to act under mistaken notion so as to cause harm in the question. Whatever harm that is in question, if that is accomplished, how is it accomplished? By mistake, under mistake, isn't it? An innocent person is acting, and he is acting under a mistaken notion. Though it is a mistaken notion, but yet the cause is harm. So whatever harm that is in question, that is being accomplished, though to an innocent act of a person. So what will be the consequence of that? By taking an illustration again. Now there is one Mr. A, he is trying to kill somebody. Now in the process, the method that he adopts is get some poison, mix it with food thoroughly, and such a poison which doesn't give any smell, which doesn't have any taste and all, so that it can easily be mixed with the food and then it can be administered. So planning this, he brings some poison from a shop, and then he wants to kill B. Now what he does is, natural course, he knows that B is in the habit of taking food from a table, and then he knows where that table is, and then he keeps that poison laid food on the table, and he is waiting for B to come there and then take his dinner or lunch, whatever. Now meanwhile what happens? There is one C, B not knowing about the poison in the food, and then serves it to C, isn't it? B is normally, he is in the habit of serving C. He is a third person. Now that food is served to C. So what happens? C dies, isn't it? So A has a knowledge that C is B in the natural course, B serve the food to C because he is naturally in the habit of giving food to him, and B doesn't have any idea because normally he is probably a servant in the house, and then normal course he serves the food. But the fact is not known to him that this particular food which is going to be served to C is laid with poison and all. So in the process C dies. A is fully liable for this particular act if he has committed. And what is the liability? His liability, he is liable for committing murder, and his act also is actus reus. So I hope I am able to make distinction under three different instances and three different circumstances. So in this last illustration, what a person does is he mixes poison in the food which A knows. That means A has knowledge. What is the knowledge? In the natural course, B serves the food to C, and A's intention is to kill C, isn't it? But he is not directly doing it. He is not directly doing it. So he knows, he has the knowledge that B is a servant, and B is definitely going to serve this to C, and by any chance if he consumes, C consumes, he is definite to die. So, but that particular knowledge that this food is poisoned is not known to B. So, B not knowing about this poison in the food, as usual serves it to C, and in the process C dies, and A cannot take a claim or a plea saying that I never killed C, it is B who killed C, isn't it? My direct participation is not there. Maybe I have some ill feeling, some intention, but that intention never got manifested into an action. I never killed C. He cannot take that kind of a plea, and then he cannot claim any defense under that. So whatever act he has done, though it is indirect, we can still call that as an actus reus, that is act which is prohibited and then which attracts punishment under the act. Am I clear about these concepts? Should we go ahead? Yes, please. Yes. Go ahead, please ask. Yes. See, B is innocent. You cannot attribute any criminal liability to him. Why? Neither he has intention. He never intended to kill C at any part of time, nor he has knowledge that if I do this, it is going to end in some evil consequences. Only then that part is called actus reus, isn't it? Not every act is actus reus. That's what I am trying to impress upon. There are two people here. A is one person, B is middle person, C is the person actually whom A wanted to kill. But then he doesn't want to directly participate in the event, so called the crime. So what he does is, he thinks that he can escape liability by not participating in the crime directly. But yet his action can be punishable, isn't it? How the logic behind is that A has intention because he has some ill feeling, he wants to finish C, but then he doesn't want to be in the picture. So how can he achieve killing of C? He knows that in natural course B is a servant who always is in the habit of serving his master called C. So B very innocently, because it is his daily habit, natural course of action, he serves food for C, isn't it? So B as usual goes with a good intention because his master is very hungry at this particular hour every day. I give him food. So now it is today also it is my turn. It is my time. So timely I need to serve food to my master. So with that good intention, not knowing that this food has got already poisoned, so he goes and administers the same to C, so-called master. Now what is his liability? He has neither intention nor knowledge, and then knowledge means knowing the consequences. If I do this, there are going to be bad consequences. Neither he has knowledge of that, nor he has intention. Why should he be liable? There is no liability for him. He is innocent. Law is not going to punish him. Am I clear? But whereas A, even if he takes the plea that see, I have not directly participated. No, actus reus, how it has to be understood. I am only trying to give you examples. Not all acts are actus reus. Only certain acts are actus reus. So actus reus means participation in a particular act. Whether the participation is direct, indirect, or no action at all. In either these situations, when we call an act as actus reus, when we don't call a particular act as actus reus, can be understood in three different situations. That's what I am trying to give you, tell you under three different heads, and then in each case how an act can be simple act or act is actus reus. Hope I am clear. Yes, could I answer your query? I don't know the name of the. What's your name? Some Vishwa. So there are different situations. There may be direct participation, there may not be direct participation, there may be indirect participation. There is no action at all maybe. So these are some heads, and then the last head being novus actus interveniens. INTERVENIENS. Novus actus interveniens. That means what? We'll try to understand that. If suppose the new act intervened is only a reflex action, not the actual original action or original doer, and in that case defense will not apply. But if it is totally an independent act of the third party, then the act of the original doer does not amount to actus reus for the harm caused as the chain of causation. It is, in this case, is breaking. Now, how to understand these things? Let us take again examples and then try to understand how the concept called the novus actus intervenens, how to understand that. Now, let us take an example. There is A, there is another person B. Now, A has got a strong intention to kill B. That means A intending to kill B. And then some material object he has to use, either a knife or either a pistol, something he has to use, some material object to commit the crime. So in this case he takes a gun and then shoots at B. But then it so happens that instead of killing B, it can only effectively cause some wounds, a very slight wound, let us say. B sustained only a small injury, let us say. That means A's intentions is bad, he wanted to kill, but he is not a very good shooter, let us say. Or B is standing in a very far distance, let us say. So he is trying his level best to kill him by shooting at him. But then it so happened that instead of killing B, it slightly wounded him, let us say. Now, what do you say about the mens rea of A now? What is the liability, criminal liability that we can attribute to A? Undoubtedly we can say A has got a clear mens rea. Why? Because he has strong intention to kill B, isn't it? What is the mens rea? Mens rea is to kill, murder, isn't it? That means what? He foresees what is the consequence. Foreseeing means what is the consequence that comes out of my act. That is called foreseeing. Now, plus in addition to foreseeing the happening, that is the act, he also has a desire or intention, strong intention rather, or strong desire to kill B, isn't it? Now, what happens? This is the scenario. What happens on his being taken to the hospital in an ambulance? Now, he is slightly wounded. So it is but natural when somebody gets wounded, he will be taken to hospital in an ambulance. Now, that ill-fated person B, it so happens that a piece of there is some construction work going on, and suddenly a big chunk of machinery from the building, it comes and falls on the ambulance, and then in the process, in the melee, B gets killed. Are you getting me? By wounding, by shooting at, by sustaining an injury from a shot, he never died. It was only a slight wound. But then he is so ill-fated that while transporting him to the hospital through an ambulance, it so happened that there is some constructive work going on, and a very big chunk of that construction material has accidentally fallen on the ambulance, and that crushed him to death, isn't it? Now, or alternatively, we can also say that A has got a very rare blood disease. He is suffering from some blood disease, let us say. And what is that disease? Once blood oozes out, it will be very difficult for such a person who has this particular kind of a blood disease. His blood never coagulates, and then there is a constant bleeding from the wound. And then, even though initially it was a slight wound, it is because continuously the blood is oozing, it is not coagulating. So in that case also person may die, isn't it? Which would not have done, I mean, that death could be avoided when, if he is not suffering from that particular disease, isn't it? Or another example, alternatively, we can say that now A is refusing. He says, I don't want my wound to be treated. Though I sustained a wound, I never want it to be treated. So if any wound which is open and all, if you don't treat it, it will lead to blood poisoning, isn't it? Some septicemia and all may occur, and the person may ultimately, after a few days, he may also die. So that would not have happened if the wound is treated, because he is vehement upon, he is refusing, he is not taking any treatment, he denies any treatment. So slowly there is poisoning inside the body, the septicemia is happening, and ultimately the person will die. So in all these illustrations what we have seen, the problem is causation arises. What is that? Did A cause B's death? Did A cause B's death? What is your opinion? What's your opinion? And I know that Advocate Saab can answer, but I want others, those who have no background of law, to answer. And why? Advocate Saab says, yes, A is liable. Now I want others to react. Why A should be made criminally liable? What is his criminal liability? Should he be declared innocent, or is there some intention? But then wounding a person is also an offence. I mean, with a strong intention, the intention is nothing but a desire, strong desire, motive to kill, isn't it? But maybe he is not very successful. But initially his intention was to kill, not to wound, isn't it? Not mere wounding. His intention is strong, he wanted to kill B by any means. But it is his failure. He is not that successful. He is only, I mean, he could only successfully create a wound, very slight wound, isn't it? So wound per se may not result in the death of the person, but there is some intervening factors. What are those factors? There are alternate situations I am trying to give. In one case, B denies, he refuses. It is slight wound. I don't believe in going to the doctor frequently. Let the wound heal on its own. I don't want any treatment. He may refuse. But then it so happens that the wound, because it's an open wound and all, it is prone to infection and all, and then there is infection spreading through blood and all, it led to septicemia, ultimately the person dies. And then A cannot just say, since I have only created a slight wound, so my legal criminal liability to be, it should be restricted only to, injure a person. To that extent, let there be some criminal liability to that extent. He may plead that also, isn't it? But then how to prove his intention? That is the point. Now when the intention is strong, and when his intention is to kill the other person, he cannot take a plea. How will you prove that? By all other circumstances. See, when his intention is only to wound him, out of fit of anger and all, he could have used a very less severe kind of a weapon. By using a firearm, it will definitely any injury caused by a firearm will lead to death of a person, isn't it? He is very sure. He knows the consequences of the act. That is, by shooting with a weapon, a firearm, that will definitely lead to a consequence, evil consequence, that is the death of the person. But then because he is not a good shooter and all, he missed the aim, and then it only resulted in the wound, a simple slight wound. But that doesn't mean that he cannot say, because what are the circumstances? Carrying a weapon, loading it, these are all intentions. By his own outward actions, you can say that there is a strong intention in the mind of the person, and then that is provoking him to kill the person, the other person, isn't it? The other situation that, so that intention is to kill. So all three have taken place, but only thing is, can he be made criminally liable only because the outcome of the entire act is only harm? Only it resulted in a small slight wound. But can he now take a plea in the court of law that I am only, though my intentions are bad and all, that resulted only in a slighter harm, not a very big deleterious harm. So can he take the plea and then take the shelter under this particular thing and then say my liability only is to the extent of harming the person, not you, I should not be unduly put under section 300 or 302. If suppose that is his plea, will he be successful in putting forth that plea? But then the prosecution, how the prosecution is going to prove that? Because it is, after all, the onus is on the prosecution. They need to prove. That's what I am saying. That's what I am saying. See, he survived because there is no, the A is not a good shooter. Had he been a good shooter, he has got all intention, he has got all knowledge that with this strong intention, if with such a deadly weapon, if I am going to shoot at him, that will definitely result in the death of the person. All this is there. But the other circumstances is proving, the situations are proving, that is carrying a weapon, a very deadly weapon, and then that too loading it, isn't it? Yes. Then my point, correct. My point is, what should be the liability of this person? Definitely he is liable for some punishment. Depending upon the criminal liability only, that the magnitude of punishment will be levied, isn't it? So can he take the plea? No, it's not the subjective opinion of the judge, isn't it? He has to go by some circumstantial evidences also. Now, how can the prosecution prove that there are also other strong circumstantial evidences to prove the guilt or the liability, criminal liability of A is that he has made all preparations? That is number one. That means what? Why should, intention is there. Intention can never be seen. How intention can be understood in this particular case? What is the preparation of that man? He has prepared himself thoroughly well. There is an attempt on his part. There is a preparation, isn't it? All that which, brought a weapon, yes. Loaded it, yes. Used it. And he also attempted to shoot. Only thing is, a failed attempt. It's not accomplished attempt, isn't it? Had it been an accomplished attempt, fully done, the offence would have been committed, isn't it? That means that would have definitely resulted in the death of the other person. But the only thing is, in the last stage of commission of a crime, he was a failure. He could not accomplish the desired task. desired outcome. What was the desired outcome? To kill the person, isn't that was the desired outcome? But then it has resulted not in the desired outcome, unintended outcome. What is the unintended outcome? That resulted only in slight wounding of the person. Just because the outcome is only a minor offense, he cannot take a plea. But then circumstances also the judge has to take into account. When intentions are very strong, he probably, in my opinion, cannot take a plea under the guise that it resulted only in slight wound, hence please punish me only under give me punishment which is slighter, isn't it? He cannot do that. And again, circumstances, prosecution version and all, they should be successfully, they should prove that and then bring all witnesses who saw him purchasing that, who in his course of communication he must have said, see, I bore grudge against so and so, at least to his friend or relative he must have confessed and all. So these circumstances evidence also do play a lot of role in deciding the fate of the case. So now these are all the things. Now there is another element, especially in civil cases and all, probably this may work out, but not in criminal cases. What is that? So victim's contributory negligence. Victim contributory negligence, he is also, he should take care of his body and all. He may say that these things, I mean, there is negligence on the part of the victim. Had she or had he been little careful, we could have avoided that and all. These are the pleas that are good when they are good defense rather. When you talk of I mean civil proceedings or civil law, it is allowed, but rarely or no instance in criminal law or criminal cases. It was never a defense in criminal cases. So victims contributory negligence also, I mean whether it can be actus reus, definitely not in criminal cases. Of course, yes, a good defense in case of civil law. Now, participation of the accused is superfluous, we can say. Even if the act is superfluous, now we can say the doer is jointly liable with the original donor. So, this is about the thing. So, in summary, what we can say in actus reus is that there are three very important characteristic features that make the act of the offender actus reus. Not mere acts, but they are definitely actus reus. So what are those three ingredients or three traits or rather three characteristics? One is definitely the human element is there, or if not human element, you can say a person, including juristic or legal person also, or a company, and there should be definitely an act, and then that act is definitely prohibited, forbidden by law. Number three is, and what is the consequences of that act? Will that act lead to a consequence which is bad, which is harmful, rather deleterious? In such case, then it is punishable, isn't it? This the natural consequence of that act amounts to crime if committed by the doer with the prescribed mens rea. So that means there should be accompanied mens rea, guilty mind also, that has to be there. Only when that accompanies, then we call that act together as the crime. Actus reus plus prescribed mens rea is definitely a crime. So these are some of the characteristics when an act can be called as actus reus. Under how many different headings we can understand actus reus, where there is direct participation, whether it is indirect participation, or some intervening factors, or where there is no act at all, yet there are some sections which say mere assembly, like unlawful assembly, 144 and all, we try to understand. And one essential part of the crime we have understood so far. Now about mens rea, which is also very important, probably tomorrow's class we'll try to understand Menseria. So actus reus, Menseria are very very essential. Unless we thoroughly understand it, we cannot understand any crime. So most of the sections they only talk about Menseria, actus reus. These are the only two very important confusing elements that compose the crime. So I request all of you to again go through the PowerPoint I have already shared with all of you. Read it. Come tomorrow. We'll at the same time we'll assemble. If you have not understood anything out of today's lecture, you can after going through it, if you have not understood it, you can again come back and then clarify that. So as for today, we can close the session, we can leave the meeting. Yes, yes. Bolo. Today's class, as I told you, my laptop got spoiled, and then I am taken some print